Welcome to U.S. Immigration TV. In this video, I'm going to be discussing how a Filipina mother was put in deportation because she did not submit a document. Now, recently, there was an elderly Filipina mother being petitioned by her U.S. citizen daughter, but she was ordered deported or removed because her daughter allegedly failed to include the daughter's latest tax return when she submitted an affidavit of support in connection with her mother's adjustment of status application. I mean, can you imagine that? One missing document and it results not only in denial but deportation. So what's even more shocking is that the deportation proceedings and the deportation order happened less than a month after the adjustment denial. Trump is really moving fast. It's like denies, put you in deportation, and then you have your hearing the next month. Now, this case, in my opinion, goes against Trump's claims on focusing on enforcement priorities. Remember that? Where he promised in his immigration crackdown to focus on deporting felons, terrorists, and others who pose a threat to our safety or national security. Now, what threat? Really, think about it. What threat does an elderly Filipina mother pose, especially when she had an approved petition from her U.S. citizen daughter and was otherwise eligible to adjust status? I mean, she was probably staying home, watching after her grandchildren. Now, why is such a case considered an enforcement priority? It was just an innocent elderly mother out of status, but still under petition. So this case should serve as a warning to you that the Trump administration is getting super strict, and it seems it's almost looking for ways to deport people even if they don't constitute an enforcement priority. Now let's go through the facts of that case. You have a U.S. citizen daughter petition her mother in 2022 and also filed for adjustment of status. The daughter included what she thought were all the necessary and required documents. Now, the daughter's petition was duly approved, and the U.S. Citizenship and Immigration Services, or USCIS, on their online case status indicated that as of October 2023, the case or the adjustment was under review, meaning no problems there. The online case status indicated that as of January 2024, that there were no outstanding requirements or documents needed. So if you're a person under petition or a person petitioning a family member, you'd probably be reading that and saying, hey, everything's fine. I just have to sit back and wait. However, there was a request for evidence, or RFE, that was served. And it asked for the daughter's most recent tax returns, which she timely submitted in April of 2025. Again, when you go and you file anything, the USCIS website lists what are called the required documents. And of course, when you have the affidavit of support, which is required, another thing is the backup tax returns. So USCIS asks for the most recent tax returns, daughter sends them in. However, the USCIS went ahead and denied the adjustment anyway. So the daughter immediately files what we call a motion to reconsider, stating she had submitted the requested documents. She timely requested, and I guess she had all the proof of it, which is also important. When you send anything out, keep a record of it, document everything. In writing, no phone calls or, oh, I remember or I think. No, document well. Unfortunately for this family, That motion to reconsider was rejected because the daughter submitted the incorrect filing fee. Now, this rejection notice was then followed by a notice to appear, or NTA, that was issued in September of 2025, placing the mother in deportation proceedings with a hearing date the very next month in October of 2025. I mean, can you imagine from denial to be placed in deportation and then getting a hearing? Typically, sometimes USCIS did not follow up or does not follow up with deportation after a denial of adjustment, depending on the circumstances, but ordinarily they deny it and you don't hear from them again. Or if they do put a person in deportation, sometimes the hearing date is maybe a year or two in the future. Here it's bam, bam, bam. NTA hearing next month. So unfortunately, in this case, when it came time for the hearing, the poor nanay, the poor mother, had to be rushed to urgent care on the date of the hearing and therefore could not attend the hearing. Nevertheless, the court went ahead with the hearing and ordered the mother deported or removed in absentia, or in her absence, all because of a missing document, a tax return, when the daughter was filing for adjustment of status. So what's even more amazing to me is how quickly the hearing was scheduled after the denial, especially when we are hearing about people encountered at the border with their asylum claims, where sometimes they wait years before a courtroom becomes available. And we're always hearing about the tremendous backlog in the immigration courts. So it's just astounding, baffling to me how this case went through so quickly, and especially when the mother really was not an enforcement priority. So in this particular case, this mother would need to quickly file another motion to reconsider the deportation order or an appeal, especially if the requested documents were timely submitted. If it were me, I would fight this deportation, even if we have to go into court proving eligibility for the adjustment of status, establishing the timely submission of the requested documents. Also be aware, once a person is put in deportation and the case is at the immigration court, USCIS will not look at it anymore, saying we don't have jurisdiction anymore. So it's likely this poor mother has to go through a hearing, but if it were me, I would be fighting proving her eligibility. But I just think that this particular case is what I will call overkill. To first deny a case over something as insignificant as a missing document, which was actually timely submitted, and then to immediately place the Filipino mother in deportation when she was eligible for a green card through her daughter. I know that many people believe they have a simple, straightforward case and they can handle it themselves. I'm sure that that's what that daughter was thinking. Hey, I'm a U.S. citizen. This is my mom. She's committed no crime. She's eligible. Why do I need to have an attorney? But now you can see how strict and detailed the Trump administration has become when processing cases. Now, if a document is missing or a form is not filled out correctly, or you check the wrong box, then not only could you face a denial, but as you can see from this case, you could be placed immediately in deportation or removal, even if you are eligible for a green card. That's why I would recommend that whatever you're applying for, however simple and straightforward you may think it is, you should probably consult with an attorney to make sure all eligibility requirements are met, all forms are properly filled out, all required documents and supporting evidence are submitted to greatly increase your chances for success. Now, I hope you have found this video helpful and informative. In fact, it is a little bit traumatizing to see how strict Trump and his administration is with immigration adjudications. They are not only targeting the felons, the terrorists, but also the Lolas. If you found this informative, please share this video with your family and friends, and most importantly, don't forget to subscribe. I'm Michael Gurfinkel, and thank you for watching U.S. Immigration TV.